This is Barry Zalma speaking for Claim School Incorporated's video blog, Zalma on Insurance. Today we're going to speak about why refusal to pay a claim starts the running of a private limitation of action provision in a policy and how that provision will defeat a late lawsuit. Knox Mediterranean Foods appealed the trial court's grant of Appellee Amtrust Financial Services motion for traditional summary judgment on Amtrust's affirmative defenses of limitations in one issue. Knox contends that summary judgment was improper because there was a genuine issue of material fact as to when its claim accrued. In Knox Mediterranean Foods v. Amtrust Financial Services, the Court of Appeals of Texas in Dallas on July 28, 2022, interpreted the private limitation of action provision in the Amtrust policy. The background of the case was that Knox owned and operates a restaurant in Dallas, Texas. Knox purchased an insurance policy from Amtrust that covered various losses, including theft. The policy provided that any claim for breach of the policy must be brought within 2 years and 1 day from the date of the cause of action accruing. The policy defines accrual of a cause of action as the date of the initial breach of Amtrust's contractual duties as alleged in the action. On June 16, 2016, Knox was burgled. Knox submitted a claim to Amtrust under the policy and provided a list of damaged and stolen property. On March 15, 2017, Amtrust issued a check to Knox in the amount of $8,547.65, along with a letter from Amtrust's claims adjuster stating that the check covered stolen camera equipment. On June 13, 2017, the adjuster wrote stating that he needed additional information before he could pay more. The letter stated, quote, "We have requested supporting documentation for the other items you claim multiple times. At this time, it has become apparent you do not intend to provide any additional documentation, and therefore, pursuant to my letter of March 15, 2017, we are closing this claim for possible contents damage with no additional payment." On May 20, 2021, almost 3 years later, Knox filed suit against Amtrust. Amtrust defended, claiming that Knox's claim were barred by the private limitation of action provision of the policy. Amtrust argued that Knox's cause of action accrued on June 13, 2017, when Amtrust notified Knox that it was closing this claim for possible contents damage with no additional payment. The trial court entered a written order granting summary judgment and ordering that Knox take nothing on its claims. While Knox's brief wholly failed to cite the record comprised 425 pages, roughly 300 of which is the insurance policy. The sole issue on appeal required the court to consider whether Amtrust's June 13 letter constituted a denial of Knox's claim. The letter is little over a page long and easily located in the record, and so the Court of Appeal decided to work on the case even though Knox failed to comply with the rules of court. The time in which a plaintiff must file suit is defined, as the name suggests, by statute, and parties may contract for a shorter limitation period provided that the contractual limitations period is not shorter than 2 years, and that's exactly what Amtrust did. A cause of action accrues, and the limitation period begins to run when the facts come into existence that authorize a party to seek a judicial remedy. In first-party insurance actions, the insured's cause of action accrues when the insurer denies a claim. There is no dispute that the insurance policy at issue sets a limitation period of 2 years and 1 day from the date of accrual. Although an insurer's denial must be in writing to trigger the limitation period, there are no magic words that must be used to deny a claim. Any statements or activity on the part of the insurance company after the fact involving the claim do not forestall or renew the limitations period. When an insurer denies a claim, its mere willingness to reconsider that denial does not restart the limitation period. Therefore, Amtrust's June 13 letter to Knox unequivocally communicated a decision to deny coverage. Amtrust established as a matter of law that Knox's claim accrued, and the contractual limitation period began to run on June 13, 2017. Because Knox filed this lawsuit on May 20, 2020, nearly 3 years after its claim accrued, its claim was time-barred. In my opinion, the covenant of good faith and fair dealing applies to the insurer and the insured equally. When an insured fails or refuses to prove its loss, it leaves the insurer no choice but to deny the claim rather than continue to beg the insured to fulfill its promises. Since Knox did nothing for almost 3 years after it was told Amtrust would pay no more, its suit was time-barred and it recovered nothing. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,550 blog posts. If you view the videos on rumble.com or youtube.com, you can also subscribe without charge and will gain access to the more than 500 or more videos already online. And if you watch this video and approve it, please click on the like button at YouTube or the thumbs up button on rumble.com. Please also tell your friends and colleagues about this blog and the videos, and let them also subscribe to the blog and or the videos. And if you wish to see more information in detail about insurance, insurance claims, insurance law, and insurance fraud, consider for a very small fee subscribing to my Substack publications and or my locals community. Thank you for your attention.